Hello, everybody. Welcome to Orange Tree's webinar, our quarterly compliance update, second quarter of 2022. I can't believe it's April already, Heidi. Man, can you believe that?
No.
I don't know where the first three, almost 4 months have gone, 21st. We are letting people join, so we'll begin our webinar momentarily. Mike said he thought you guys saw minks or mink back here behind our office the other day. Is that what, do you agree with him?
Yeah, it was kind of little. I don't know if minks are big or small, but it looked like that. Yeah.
I asked him how he knew it wasn't a weasel. I'm not sure I bought his answer. I'm going with him. He said the fur on that little creature reminded him of a beautiful fur coat. So I thought that's good enough for me.
It was pretty.
All right, we have some people still joining. We'll just hold on for a couple more seconds and we'll get going with today's hot topic, compliance. We knew you're going to have to figure out a way in Zoom to import everybody's LinkedIn profile photo as we look at the participants list.
That would not be creepy at all, right?
All right. Well, it looks like we may have a couple of folks continue to join. I know we have typically we take all 60 minutes. Heidi's got some great content, some good updates, and hopefully we'll have a few minutes here at the end for some questions. So we'll go ahead and get going with Orange Tree Employment Screening's quarterly compliance update. Just before we begin, a couple of things. One, we are recording today's webinar, so just please be aware of that. We are offering and do offer continuing education credits. That was probably part of the pre-email and post-email when we send out a link with the recording to today's webinar. Feel free to review again, share with your colleagues. We will have information on how you can receive those continuing education credits. So please look for that in the email. And that's about it. We'll get going here. Just a couple of things from Orange Tree, what really drives us, and that is we want to become your teammate and trusted partner. We take that pretty seriously. We know it's something that has to be earned, with each and every service that we run and each and every background check that we perform for you, our clients. And so we aspire to do that each and every day. We would hope that at a point in the future, after doing business with us, that you would consider us your trusted partner. Overall, we accomplish that by designing a background screening program that's designed in your best interest. It's all about you, whatever packages you want for the different positions you're hiring, whatever you evolve to in terms of services and whatnot, increase, decrease. It's all about what you need at a given moment in time to align with your business policy with your hiring goals. We know that your time matters, so we do our job so you can do yours. You turn over the background screening program, you just want to go back to your job and fill in open positions, and you want to know that your candidates are taken care of. You want to know that all the services that you need to review are being run and being run well. And when those reports come back, the candidate's fired up to begin their position with you. So that's what we focus on. Everything's fast, everything's easy, and with single clicks, single views of information, you can get what you need. It's all about you filling more positions. We believe we're the no compromise background screening provider. And what we mean by that is we have full services, the typical criminal checks, verifications, et cetera, that you would want run, drug testing, occupational health services. We provide the comprehensive portfolio of all those services. If you have any questions about what those are, feel free, of course, to reach out to us. We'll tell you all that we do. We then, in terms of delivery to you, we think there's three things that matter most. And it's not so much that we think about it, it's that you've told us it matters. And that is, we need to have a certain expectation for technology. We deliver on that with our proprietary platform. Our software development team continues to evolve each and every day on behalf of our clients and marketplace demands. We know, and today's an example, that you expect things to be done right. We do it. And Heidi will tell you a little bit more about where we're at in that process. But Heidi is our VP of Legal and Compliance that oversees our department to ensure that everything that we do is right. and on your best effort, best policies and procedures. And finally, despite all that, you still have to have customer service. You have questions along the way, your candidates have questions, and we know that you deserve an excellent customer service experience, and we deliver that. So we just encourage you, if there's anything lacking in any of these areas, give us a call. You don't have to settle for bad experience. You can work with Orange Tree. So without any further ado, I'll turn it over to our keynote speaker, Heidi Seaton, who again, as I mentioned, is our VP of Legal and Compliance. Take it away, Heidi, and thank you very much for today's webinar.
Thank you, Jeff. You seeing the slide okay?
I can see it.
Okay, great. So welcome, everybody. Nice to talk to you again. As Jeff mentioned, this is we're going to talk about compliance today and background screening. For those of you that are sort of newer to the series, we do want to make sure you understand we're not giving legal advice. This is intended to be educational in nature. Please read the disclaimer. We do usually cover what's going on sort of at the federal level, what we're seeing. Sometimes that's litigation, sometimes it's legislation, sometimes it's regulatory news. So we'll cover what's going on federally today. Actually more news than usual at that level. So that's exciting. We'll talk about some things that are happening at the state. I think this is the first time that I've ever done this series that I don't have anything new at the state level from a ban the box standpoint. So shocking, but we are really very early in state legislative session. So expect we'll have more updates on that as we move into next quarter. But we do have some updates regarding state court access, and then just a ton of activity going on regarding drug testing laws at the state level as well. So we'll cover that. And then if we have time at the end, I thought I would just talk a little bit about as state drug testing laws are changing and quickly, especially related to testing for marijuana, just giving some sort of a roundup or summary of things employers should be thinking about as they are looking at their policies, as they're considering how these changes in marijuana law should affect their policies and their practices. So we'll do that at the end if we have time. So, oh, I didn't introduce myself, sorry. I'm Heidi. As Jeff mentioned, I'm the VP of Compliance here at Orange Tree. I've been here at Orange Tree for about 14 years working in compliance, and then about 10 more years before that. So lots of experience regarding background screening and working with clients on background screening in their programs. So that's me, in case you haven't spent time with me before. So jumping into what we're seeing in the news at the federal level. Form I-9, a couple of things going on with Form I-9. So in March, we had an invitation to comment from the DHS, so the Department of Homeland Security, which is responsible for the I-9 form, proposed some changes, significant changes actually, to the I-9 form. So for instance, they're talking about, compressing sections in 1 and 2, so they're back onto one page, which I think employers will appreciate. Changing section 3, so it's more like a supplement, and it allows for up to 3 rehires or reemployments on that same form or page before you'd have to start pulling in additional versions of that page for your form. It has an updated link to a list of acceptable documents for List C documents, and significantly reduces the instructions. So right now, as you know, there are 15 pages. So they cut it in half. 7 still seems like a lot to me for a otherwise relatively short form, but still lots of instructions there, but I think still helpful to employers. So a few more things going on with that I-9 form. They did do a 60-day comment period, so employers have until May 31st to make comments. But that I think would be a significant change to the I-9 form if it does get changed as they are proposing in this notice. So a little news from I-9. The other I-9 news that we want to just make sure employers were seeing there was a reminder from DHS that came out. I just got it this week or last week, I think, a reminder that their temporary policy for accepting expired List B documents is ending. So beginning here, that was a COVID policy, so they were allowing employers to accept expired List B documents because of COVID and sort of the impossibility in some cases of getting new documents. But they're saying now, beginning May 1st, employers will no longer be able to accept expired List B documents. And employers, don't forget, if during COVID you accepted expired List B documents, you now have an obligation to go back and get those forms updated with an unexpired form by July 31st, 2020. So that's actually a fairly short amount of time, especially if you have employees or current employees that maybe haven't started a process of getting a new version or an unexpired version of a List B document. So a good time to be looking at your records for I-9 forms that were collected. Again, that time frame was May 1st of 2020 until April 30th of this month of 2022. And just start to get an idea of which employees were affected and start following up with those employees for the unexpired document. Just a couple of notes on regulator activity. So the Consumer Financial Protection Bureau, so they are a regulator of the Fair Credit Reporting Act, so we talk about them somewhat regularly. They do a semi-annual report of credit reporting complaints, and they published their semi-annual report in January of this year. They reported in the timeframe of January 20th to September of 2021 that they received more than 800,000 consumer complaints, and consumers described harms stemming from failed attempts to correct incorrect information, inaccurate information on their credit reports. So it seems to be the big two. And credit or consumer reporting complaints accounted for 70% of all the complaints they received during that time. So again, some of this reporting was related to credit reporting agencies, so credit bureaus, but it also applied in some cases to consumer reporting or background screening companies more broadly. So it's a report that we look at twice a year, interesting information. This is a follow-on. If you remember, I think we talked about it last year. The CFPB had issued an advisory opinion affirming that consumer reporting agencies are violating the law if they engage in shoddy name matching procedures. And specifically, they affirmed the practice of matching consumer records solely with a name was illegal under the FCRA. I bring this up, I know it's sort of old news, but I bring this up because a little later in the session, we're going to talk about some of the state access issues that we're having in the industry, just a few states that have started to try to regulate away the ability for consumer reporting agencies to access consumer PII, like dates of birth and other identifiers in the public record related mostly to criminal records. And so at the same time, states are trying to legislate away our right to have that information because we need that information in order to make matches that are stronger than just name matches. We've got this regulatory activity saying, sort of putting us all on notice that, a practice like that's a name match only would be shoddy. So some interesting regulatory activity in the last couple of months, and we're keeping our eye on that as well. Ban the box, as I mentioned, I almost always talk about ban the box. I sometimes spend many minutes talking about ban the box, usually at the state level in these sessions. Today, we're actually, this is a reminder, we talked about this last time. I wanted to make sure I included it again because it just went into effect end of of Q4 of 2021. So still fairly new, but so the ban-the-box regulation or legislation actually applies to federal contractors. So the ban-the-box provision was inserted into the National Defense Authorization Act. That was passed in 2020, but it became effective at the end of 2021. And it says, in this case, federal contractors, make sure you're not inquiring about an applicant's criminal history prior to the conditional job offer. And it's clear too, by the way, that such an inquiry is both, you asking the candidate directly about their criminal history, and also if you're getting the information from other sources. For instance, if you're thinking you can run the criminal background check to find that sort of information prior to the offer. The ban-the-box provision in the NDAA effectively precludes that. Again, this is for employers that have federal contracts. It has exceptions. It talks about exceptions like law enforcement, for national security, for individuals who have access to classified information, and more. So again, if you are a federal contractor employer and you are not already only asking about or background screening post-conditional offer, this would be time to really carefully take a look at that provision to see if any of the exceptions apply to positions that you're hiring for. So that is, again, fairly new, but it was federal legislation. So I wanted to just make sure our federal contractor employers were aware. Also at the federal level, just early last week, I think, the US House passed legislation to remove marijuana from the federal schedule of controlled substances. So it's that federal schedule that sort of determines whether or not a drug is legal or use of a drug is legal or illegal. And so this is in general a response to state legislation, right? States are legislating decriminalization, medical marijuana, recreational marijuana use. We're seeing more and more of that. That'll come up in the slide later. But really, I think a response to what's happening at the states and sort of an effort to try to apply it, create a law that applies across all of the states. And it did pass the House, so it's pending. It was called it was HD 3617. If anyone wants to keep track of it, it's called the MORE Act. And it does high level, very high level, right? Three things. It eliminates criminal penalties for manufacture, distribution, possession of marijuana. It provides for regulation and taxation of legal sale of marijuana. And then it expunge or results in expungement of federal marijuana convictions going back to 1971. That seems to me a significant expungement or decriminalization effort. So if it does pass, I think you'll see a significant impact to a lot of individuals with criminal records. And I will say the vast majority of drug offenses are adjudicated in state court under state law, right? So this wouldn't affect that necessarily, but it might push more states who haven't already towards a decriminalization of their own marijuana criminal statutes. So that could happen. It would also help, so it would bar denial of federal public benefits or security clearances based on marijuana defenses. And so the question about legislation is always, you think it's going to pass. And I think, I will say it's similar to legislation that passed the House in December of 2020. At that time, it never came up for a vote in the Senate. It was Republican-controlled Senate at that time. We do have a very slim Democratic majority this year, so I think it's more likely to come up. And we'll keep an eye on this one. Other big news at the federal level related to drug testing. And this is specifically the DOT regulation. So it applies only to employers or individuals that are in safety sensitive positions, as that term is defined in the federal regulations. But so we have in DOT regulation news a notice of proposed rulemaking. I was trying to think or look back how many years we've been talking about making this change to DOT drug testing regulations. It's been a number of years. So again, this is just a notice of proposed rulemaking, brings us one step closer. But what we're looking at here is a regulation that would permit oral fluid testing as an alternative drug test method for DOT regulated workplace testing. So right now, the only sort of testing that's allowed under the DOT regulation is urine-based, lab-based testing. This would allow an oral fluid lab-based test. So it feels like an idea whose time has definitely come. It would help to harmonize with the mandatory guidelines for federal workplace drug testing programs from the DHHS. In addition to oral fluid testing, it would allow for direct observation of urine collections by licensed or certified medical professionals. Would allow MRO staff to contact pharmacies directly to verify a prescription. It would allow for tests to be uncanceled when canceled by the MRO if circumstances dictate that. It would allow for use of official identification numbers issued by state or federal authorities to be used instead of Social Security numbers, and more. So if you are an employer that has positions regulated by DOT, safety sensitive positions, or any of the sub-agencies, definitely news of interest to you. Sort of fingers crossed, I think it would be great for the industry, for employers, even for drivers, honestly, if they would move forward on this rulemaking. But it's been a number of years in the making, so I hate to even try to guess on whether or not I think they'll move forward with it, and or how quickly that could actually happen. So that's what we have at the federal level. And then I'm just going to move right into some things happening at the state level. A couple of updates on some state court access challenges that we've been having. So if you've been attending these sessions, you know we've been keeping a careful eye on what's happening in California and in Michigan. And in general, what we're seeing are states, groups having with efforts to sort of remove consumer or candidate or probably defendant PII from criminal public records to sort of start to begin to keep that information private. And it's what we're seeing then is courts, sometimes it's legislation, in some cases it's court rules that are being adopted. In the case of California, we had a court rule that prohibited the display or publication of date of birth or driver's license information in a court calendar, register of action, or index. And we had a case on the subject, so All of Us versus Hamrick, where they interpreted the statute. And the California Court of Appeals held that public searches could no longer include a search where you had to input the individual's known date of birth and driver's license number. The California Supreme Court declined to review. And so what we've seen is clerks are redacting from online and public access terminals, especially date of birth and driver's license information. So what does that mean? It means we've seen delays in California. Clerks have to assist. So when we have a possible name match, clerks have to submit those name matches to the clerks. They look into the file to try to verify if there's a matching date of birth. And so we do have an update there in California. So here in August, actually I think it was in February, Senator Stephen Bradford, Democrat, he's the chair of the Senate Consumer Protection Committee, introduced SB 1262. It sort of immediately got referred to committee in March. But it is now set for a hearing here at the end of April. So we're hopeful that the bill, which would clarify that's just merely searching by a date of birth or driver's license is not the same as displaying it, which would allow us to again do more of the criminal record searches on our own without having to resort to a manual request to the clerk every time there's a possible record. So just a little bit of movement in California, which I think is good, and hopefully we'll see some traction on that bill here coming up in April or May. In Michigan, better news actually. So again, Michigan adopted court rules. That was back in December. We started seeing the courts redacting date of birth from public access terminals, from being able to search for that when doing name and criminal record searches. And the PBSA, some other professional organizations were able to negotiate with the Supreme Court, with court administrators to create a way to allow our researchers, court runners, to be able to access that information, especially dates of birth when they needed to. So effective, so that got delayed. And then there was an announcement about how it would be implemented, and the implementation date there was April 1st. So as of April 1st, records researchers, court runners can be registered with the state, with the court, as individuals that are authorized to receive date of birth information with court record searches. So how's it going? Good, actually. We're seeing courts cooperate with requests for confirmation of date of birth. We haven't seen, and I don't think we'll see dates of birth being returned back to public record terminals, or that there would be some sort of special access or permission on those public terminals that would allow our researchers to automatically see that information based on that registration. So we are still seeing it's still a little slow, right? Because we still have to submit a request to the court clerk anytime we have a possible name match to have them confirm that date of birth. But that's a really significant improvement over what initially was in the court rules that were adopted. So good news in Michigan, we are seeing things open up there a little bit. Results are speeding up, and we are seeing cooperation from the court clerks there. So then moving into drug testing, I recycled this slide from the last session's slide deck, just because it's still pretty close. What are we seeing with states legislating drug testing, especially marijuana drug testing? They're legislating away. I will say there are many, many, many bills that are being introduced, a few that are getting voted, that are moving through the legislative process. Not too many yet, actually. A lot of them are still in progress, but we're early in most states' legislative processes. So far for bills actually being passed, with just a few exceptions that we're going to talk about, we're just mostly seeing updates to existing state statutes. So for instance, where there's states where they already have an existing medical marijuana, maybe they're tweaking it, right? They're creating additional types of illnesses that where a medical marijuana prescription or access is allowed, or creating other agencies or legislating how those medical marijuana laws will be regulated. So that's like DC, South Dakota, Ohio, Utah, Maine. We've seen some laws passed already in those states. We're seeing a few laws also sort of tweaking or starting to regulate in states where there was an adult use marijuana law. So for instance, in Maine. And then a few states where we're seeing legislation of testing requirements for specific positions, Delaware and Kentucky. And then we do have just a few. So this slide is up to date. So again, we incremented from 36 to 37 states that have medical marijuana legislation since last quarter. No changes on states with recreational marijuana legislation. That's still 18 plus DC. And what we are seeing in a lot of the pending legislation are attempts with jurisdictions looking to explicitly exclude marijuana testing for pre-employment, as they did last year for Philadelphia, New York, Nevada. And we're also seeing more legislation related to testing for impairment or fitness for duty and what those requirements might be. So just a few states to go through because they're new or they were recent. Maine had a constitutional amendment that made it through as a House bill. So they've actually two of them. So again, this is pending because constitutional amendment requires ratification by voters in Maine. So that would be a ratification process that happens in November of 2022. So a little bit of time on that one, but just know the amendments would legalize recreational marijuana use for individuals aged 21 and over. And so far, no mention of employers or the workplace in either of those amendments. So employers would just sort of have to see how that would shake out as that legislation happens. So usually the way constitutional amendments are written is, the legislation passes or the amendment's ratified, and usually it has some provision for creation of an authority or an agency within the state that would then create regulation around its decriminalization, its legalization, sales, taxes, that sort of thing. So look for that in Maine. Mississippi was our, so far in 2022, new state to pass legislation. So that was SB 2095, passed and signed into law by Governor Reeves. That happened here in February. And it was with immediate effect. So it was a medical marijuana program legislation. It's fairly employer friendly. So it provides no express employment protections for medical marijuana cardholders. It doesn't require the employer to pay or reimburse for the costs associated with medical marijuana use or permit or accommodate use by employees. It doesn't require employers to modify any job or working conditions for employees who are cardholders. It doesn't prohibit employers from refusing to hire or take adverse action against employees who are medical marijuana card holders. It doesn't prohibit employers from establishing and enforcing drug testing or drug-free workplace policies. And it doesn't provide for any express legal cause of action for an individual to file a claim against an employer. Also doesn't impact employers, workers' compensation premium discount programs in the state. So far, the Mississippi legislation is fairly employer friendly. Again, this is just a medical marijuana program at this point in Mississippi. Montana, so Montana's legislation is not new, but they did just roll out open dispensaries in the state in beginning of this year. So in Montana, that was HB, I think I have an extra one in there, HB 7011. This was a recreational use piece of legislation passed in May of 2021. So we talked about it last year, but for employers, what you should be thinking about in Montana, it doesn't require employers to permit or accommodate use in the workplace or on the employer's property. It doesn't prohibit an employer from disciplining for a violation of your workplace drug policy or for working while intoxicated. And it doesn't prevent an employer from declining to hire, discharge, or discipline based on a violation of your policy or while being intoxicated while working. It does prohibit an employer from including a provision prohibiting use for a debilitating medical condition in a contract. It does not, sorry. And it doesn't create a cause of action against an employer under the state's wrongful termination or discharge or freedom from discrimination law. However, Montana, just know it does amend the lawful off-duty conduct statute. So marijuana is now considered a lawful product under the law, and employers can't refuse to hire or discriminate with respect to compensation, promotion, terms, conditions, privileges, because they legally use marijuana off the employer's premises during non-work hours. So friendly-ish to employers, but you know, it does. It's one of those states with the lawful conduct statute change that can be problematic, right? Because employers sometimes in their drug testing policies, especially pre-employment, are testing for marijuana. And when you're testing pre-employment, there's no reason to believe that a positive test for marijuana happened on that the actual use of marijuana happened on the employer's premises or during non-working hours. So that can be problematic from a pre-employment drug testing standpoint. We talked about Philadelphia last time, but again, I bring it up just because there was a 2022 effective date here. This is the city ordinance, and it restricts employers' ability to test prospective employees for marijuana with some exceptions, right? So if you are in Philadelphia, spend some time looking at this ordinance to determine whether, you know, if you're still going to be testing for marijuana, or if you are still testing for marijuana in Philadelphia, be sure that you are finding an exception here in this ordinance to continue to test for that. And then New Hampshire, we have some case law. So just wanted to make sure people were seeing this. This happened here early in 2022, but I don't think I talked about it at the last session. So this was a case where the employer, this was a case where the employee was discharged for medical marijuana use, and the employee had asked the employer to make an accommodation for him under the state ADA or state ADA-like law, and the employer didn't. And so this was an important case, I think, for employers, because it really does talk about, hey, New Hampshire employers, disability and accommodation statutes don't contain any language that categorically exclude the use of medical marijuana as an accommodation, especially there's a medical marijuana program in New Hampshire. So rather, an accommodation for a medical marijuana user is reasonable if it is always going to be a fact determination, right? So the employer needs to decide, or the court's going to decide on a case-by-case basis, depending upon the facts of the case. So employer, that means you probably need to be having doing an accommodation process with that employee, even if the accommodation they're requesting is medical marijuana use. So I do have some time, so I'm just going to spend a little bit of time on this slide because we get a lot of questions about it. So what about testing for marijuana? What are my options as an employer? What do I need to be thinking about? When must I test for marijuana anyway? When can I not test for marijuana in any case? And so I've got sort of 5 bullet points here for employers to be thinking about. When must you test? So companies that are that have positions that are DOT regulated, safety sensitive positions, commercial motor vehicle drivers, pilots, pipeline employees, are subject to mandatory alcohol and drug testing. And so far, as of today, marijuana is still illegal under federal law. So that would be sort of the one for sure case. If you're an employer and you have DOT regulated positions, you would need to continue to test even for marijuana for those positions. Most states that have legislated marijuana decriminalized it or legislated or prohibiting employers from testing for marijuana, carve out this requirement to still continue to follow this federal law. Government contractors should also be looking very closely at their contracts to make sure that they, in some cases, the contract will explicitly say that the panel of tests has to be the same as what is required for DOT regulated positions. So if you're a federal contractor, you want to spend some time on your contract looking at that as well. Employers also, I think, should be thinking about OSHA. OSHA has a general duty clause that says employers, you have to furnish a place of employment that's free from recognized hazards that are causing or are likely to cause death or serious physical harm to its employees. So what does that mean for you if you're an employer? Well, one thing to look at might be, information from the National Safety Council, which has said employees who are impaired by cannabis present a safety risk in the workplace, particularly if they work in safety-sensitive positions. So employer, think about what your obligations are to create a safe work environment for the rest of your employees as you're looking at your drug testing policy. Federal Drug-Free Workplace Act. So federal, again, back to federal contractors, skipping around just a little bit, but federal contractors are required to maintain a drug-free workplace. That's under the Federal Drug-Free Workplace Act, so DFWA. So DFWA, though, it's not about drug testing, it's maintaining a drug-free workplace. So it requires a government contractor to have a clear drug-free policy. That policy has to remind employees that possession, distribution, and use of controlled substances are prohibited in the workplace. But arguably, there's not a conflict between the FWA and state or local cannabis laws if the employer is no longer testing for marijuana, because if in that state marijuana is now legal, it's no longer a controlled substance or prohibited, then there's no conflict, right? But again, federal contractors are going to want to look closely at their contract, right? Is the same panel that's required under DOT required under your federal contract? Employers do still need to be looking too at the language of the applicable statutes that have been adopted. So especially a multi-state employer, you should be looking at the language of the drug testing laws in every state where you have people working. You want to be looking, for instance, for lawful activities or lawful products laws. So Montana, we just talked about. New York is another example where it's unlawful for an employer to discriminate against an applicant or employee for using cannabis outside of work. So you need to be careful about especially pre-employment testing. And we are seeing like this tend to be the way that states are legislating. It's the direction they're going when they do legislation. So in the absence of a drug test that tests for impairment, it's hard now in those states to be testing for marijuana. And then as we saw in Connecticut, is that the state that I just went over? I'm gonna have to go back and look. We're seeing now court opinions that say, hey, under the state's disability law, you should be considering an accommodation that that includes use of medical marijuana. So employers, just a few things for you to be thinking about if your question is, hey, should I still be testing for marijuana? These are the top 5 that I would be thinking about. And we do have employers asking us to take marijuana out of their panels in some cases. In other cases, maybe it's an employer that's not in a state that has legislated especially, for medical marijuana, you may still test for it, but then not take an adverse or make an adverse decision based on that. So I just encourage employers, especially multi-state employers, to spend that time doing the analysis, work with counsel. Let us know if you'd like a referral to consultants that can help you with the multi-state policy, taking these sort of marijuana issues into consideration, because they're important and they're not going away. I think that's my last slide. Jeff, was there any other comments that you wanted to make or any questions that you wanted me to try to field today?
Heidi, I think we had a couple of questions come in. We had one from Liz. Do we expect any revisions or flexibility for remote workers and the I-9 form?
I didn't see it in the request for comment. I will just say the federal government moves slowly. So I wouldn't get my hopes up.
Heidi, I can't believe you just said that.
I can't believe anyone would disagree with me.
Well, but that's why you're our legal and compliance, and I'm not. So invite everybody, just as a reminder, we do have some time here today, and always are happy to take your questions if you have them, if something has come up during this conversation, or otherwise that you'd like to use this time and get some point of view from Orange Tree from Heidi, feel free to do so. If it comes up to you later, feel free to send us a communication, an email, reach out to us. We'll be happy to follow up at any time you have that question. Our next question from Colin is, as for ADA accommodation for marijuana, what if construction safety sensitive function, I apologize, I should have read this ahead of time. What if a construction safety sensitive position, what if it is and cannot transfer to a non-safety sensitive position?
Yeah, I think obviously I'd run it by counsel, but I think if it really is a federally regulated safety sensitive position, most states carve those out of their legislation. So you're probably, for sure, if it's DOT safety sensitive regulated, you're going to want to follow those regulations. And then if it's a state regulated position, you're going to want to look at state law to make that determination.
Okay, we have another question. Can you have separate pools for different classes of employees, office versus warehouse, for instance, or do you need to test everyone in the pool?
Okay, so now we're talking random, I think, if you're talking about pools. And we'd have to look at, again, if it's DOT, then you've got the DOT regulations to follow. And you'd have, those regulations would apply only to safety sensitive positions.
Okay, non-DOT is, not to interrupt, but maybe just as you cover this one, then can top the non-DOT if it's applicable or different.
Yeah, yep. So non-DOT, you're going to want to pay a lot of attention to state law and what's allowed or required by state law. I don't think I can answer that question off the top of my head. I would look at the state law. It might also depend on, so a lot of times states will have drug testing laws or regulations that apply anytime you're testing in that state. Sometimes they only apply if the employer is participating in like a workers' comp or unemployment compensation insurance program. And then some states legislate don't allow random testing at all. So we'd need to do a state analysis there. I'm happy to take that offline if you want me to.
Okay. I apologize, Heidi. I interrupted your flow on the DOT. Did you have a chance to complete that? Because there's probably some people who would have some similar interest on the DOT response.
Yep. Just on the DOT side, you have to do what the regs say.
Okay.
So just, would be careful to make sure that you're following the regulations on the DOT side.
Fantastic. Looks like that covers it for now. Heidi, thank you very much. for
You're
the
welcome.
informative update to everyone. We will send out an email communication to the recording, the slide deck, so you can share with your colleagues, listen 2-3 times. Feel free to do that. And, oh, oops, I missed it. They just came in. One more, they caught me. Federally regulated financial institutions. Does the New York law around pre-employment drug testing allow us to continue to test and decline based on positive marijuana results?
I don't know. I'd have to look at the finance legislation there. Sorry.
Okay. If you'd like to send me an email that was an anonymous attendee, it just so we could respond to you directly, we would be happy to provide additional information as appropriate. I'll be the channeler of that information and look to Heidi for the actual response so you get what you're looking for. So I think that actually does close us out. Heidi, thanks for taking that last second call. Apologize for missing that. Thank you, everybody, for attending today's webinar. Look for a communication from us